Hello and welcome to today's General Counsel Institute's webinar series. Before I kick off today's webinar, I'd like to address a few housekeeping items. Regarding CLE credits, please be sure to answer the survey question regarding in which state you're interested in. We will apply for CLE credit to each state identified after the completion of the webinar. CLE credit is only available for this live day and not on demand. The survey can be answered at any time through the survey icon at the bottom of your screen, or it will pop up at the end of the webinar. I wanted to bring to your attention the resource icon at the bottom of your screen. Here is where you'll be able to download the deck as well as additional materials. We ask that you take a few minutes to express your thoughts on the webinar, ask questions to the speakers, and or socially through Twitter during the webinar. Again, all are located as icons at the bottom of your screen. We have several distinguished presenters for today's panel, Winning the Race for the Facts, case studies on how to leverage technology and search expertise for investigations and case preparation. From the law firm of Covington & Burling, we have four prominent attorneys, Ben Haley and Aaron Lewis, both partners at Covington who handle high-stakes government and internal investigations and regulatory enforcement matters, among other things. Josh Gonzalez, an associate who represents clients in an internal investigation related to civil and criminal False Claims Act liability, and Randy Friedland, an associate who is a member of the firm's anti-corruption and white-collar defense and investigations practice group. From the expert legal search firm H5, John Kilberg, who is Senior Director of Engagement and Client Management, and Steve Van Leer, who is a Senior Practice Director. Steve will be moderating the panel. And with that, I'd like to pass it off to Steve. Steve?
Thanks so much, Jen. And thanks to all of you for taking time to attend our webinar today. The topic we're going to address relates to a significant challenge that confronts any case team conducting an investigation or preparing a case for trial, particularly when the matter implicates large amounts of data. How to quickly find the information you need to understand what happened, complete a factual narrative, support or refute the elements of your causes of actions or defenses, and prepare the matter for future action going forward, whether that's advising your client on course of action, engaging in settlement discussions, or preparing for trial. The advent of electronic data, as distinct from paper documents, has exacerbated the problem of finding facts quickly because of its impact on the volume of electronic documents, potentially in scope. As we all know, the volumes continue to spiral out of control, and the challenge keeps getting bigger. The good news, however, is that because documents are now by and large electronic bits of data, they can be manipulated and searched in ways that are vastly more efficient and accurate than when paper documents require traditional manual review. But to do so requires a new mix of technology and talent. Lawyers who can partner with and leverage information retrieval experts utilizing advanced technology can win the race for the facts over either lawyers working alone or lawyers wholly delegating that task to technologists. By doing so, lawyers and their clients can avoid overspending on document review time looking for facts, hampering strategic or time-sensitive decision-making processes, and allowing critical facts to go either undiscovered or unsubstantiated. Today's webinar will begin with John Kilberg from H5, who will take us through a principled approach in which lawyers, search experts, and technologists can partner to maximize the likelihood of finding critical documents as quickly and efficiently as possible. This approach is designed for application irrespective of the particular search or review technology being utilized. Thereafter, we will take you through 3 case studies in which lawyers from Covington & Burling partnered with search experts from H5 to find critical documents quickly. I encourage folks to email questions that you may have as they arise. If the question is germane to the issues being discussed at the time, we'll try to respond as we go, and we'll save answers to broader or less related questions until the end. If we run out of time, we'll respond to any unanswered questions by email. And lastly, if we get through all of this information and answer all the questions and still have some time left, we'll try to take a closer look at H5's key document identification process and provide a somewhat deeper dive into the working relationship or division of labor between attorneys and search experts. And with that, let me hand it over to John. John?
Thanks, Steve. The key challenges in finding documents are not monolithic. Instead, there's actually a series of different challenges, each with its own, each which is known and understood. We at H5 assess each of these on every project to determine which are the most salient and adjust our approach as needed. Timelines are one factor. You might have a tight deadline to find documents for a government presentation, or the overall timeline to complete fact development and witness interviews may be compressed. Data volumes. Large data sets increase the volumes of search results that need to be reviewed. Rolling collections and productions have to be incorporated and effectively searched to ensure comprehensive coverage. Data composition is another factor. Is the data set largely emails and attachments or loose files? Are there multiple producing parties? Each of these will discuss the subject matter differently. And what's the availability and consistency of metadata? Community of practice and language use. This is really where the searcher is an outsider looking into a corporate data population. And different departments speak differently about similar subject matter. And it's hard to predict how people will talk. In a public corruption case, Zitty was used to describe the money for alleged bribes. And in the Enron case, the Raptor SPE was turned into a verb when they talked about raptorizing a process. Also, fuzzy and incomplete knowledge is a challenge. You'll answer questions you knew and ones that you didn't know at the outset. And you should expect to learn new things that will take you to new areas that you'll need to explore. You need to resist the temptation to dive into the documents. Instead, plan what you need to find and use an approach that effectively achieves those goals while minimizing the risk of missing critical information. This is the approach we use for structuring any KDI engagement. Depending on the project, we may spend more or less time on any particular phase as we assess the impact that it will have on making the work more efficient and effective. You don't have to do all of these, but do as many as you have time for given your use case. And the exception to this is target definition. So let's look at that in more detail. Target definition is a written guide or set of bullet points that specifically lists the information you want to find. If possible, have all the stakeholders in the search process involved. Determine what you're looking for, document it, and then, after you have your plan, execute. Articulate the topics and themes of interest. What kind of information is necessary for a document to be key? What kind of information might be relevant but not important? And how might key documents manifest in this population? If you have examples of key documents, that's great. But in the absence of those documents, describing hypothetical documents that would be key is very helpful. It's also important to ensure that the search expert understands the context and why the information sought is helpful or harmful to your narrative, so that she or he can escalate documents of interest even if they are not specifically targeted through a topic or search request. You also want to determine what kind of information is most useful. Is it correspondence, where you'd be focusing on emails or instant messages? Or is it memos or working papers, where you'd be searching on Words or PDFs? Similarly, financial statements or reports are most likely to be found in spreadsheets. And then finally, define the success criteria. Are you looking for a specific document for examples of behavior, or for all documents of a specific type? Target definition is useful to guard against an "I'll know it when I see it" or rabbit hole type of approaches, which usually aren't effective or an efficient use of limited time and resources. If you don't know what you're looking for, how do you know when you're done? In parallel with target definition, you'll want to reduce the noise. A maximally unique and diverse population is what we're after. Most folks are familiar with data reduction techniques. Deduplication and email threading are common, But we also use text deduplication, which looks at the text of the document without considering metadata or formatting. You can also focus on junk or bulk senders, things such as Google Alerts or 1-800-FLOWER messages. Another technique we often employ, though, is to identify non-reciprocal senders. Those are the email addresses that are never responded to. Eliminating this can have a significant impact, especially in populations like financial services companies or others where there are large volumes of third-party senders providing market information and service updates that would never be relevant. As an example, in a large bankruptcy matter, the full set of produced documents from all parties exceeded 13 million documents. But using a combination of text deduplication, email chain analysis, and non-reciprocal sender analysis reduced that search population to just over 6 million documents. Less duplicative information leads to more efficient search. You also want to boost the signal. We use analytics and other techniques to remediate or enrich the data. Data analytics can be used to supplement or normalize key metadata fields, such as dates or custodians. And some systems are able to represent emails as the component parts of metadata, header, body, and disclaimer, and make each of those available for search or exclusion. In a criminal fraud case related to bond trades on specific dates, the productions from the government were missing date metadata fields. We were able to extract the dates from the email headers and populate that as normalized metadata to allow them to be searched effectively. Data analytics can also be used to bubble up hot documents. Emotional content filters that capture heightened emotion, such as distress or worry or concern, can be used in conjunction with communication analysis that target the number of participants in a conversation. We know that direct communications are more candid the smaller the group, and this method increases the likelihood that we uncover unknown but useful information. Next, you want to prioritize the data. And this is a secondary form of data reduction that is search target specific. This is where you create a collection or a folder to prioritize the documents that are likely to have the information that you need. Some systems make it very easy to cross-cut data characteristics. We can create a document collection of emails to or from John Doe, or where John Doe is found in the email headers, within a particular date range, all in one quick search that can be used for subsequent searching. For an insider trading case, we created over 200 search collections over the course of the project for specific purposes, such as new data flowing in, depositions, and particular case themes. You already know how to create searches, but a lot of people will start off with a broad search because they're pressed for time and start reviewing. This is the one search to rule them all type approach, but it's not very effective. We've found that the net of many targeted searches is superior to a broad, all-encompassing search. Let's discuss some tips and best practices. At a high level, think of the document population as having a cast of characters. Brainstorm to predict what words they would use to communicate the behaviors of interest, or use tools available to find the most frequently occurring words in the collection. Then build a dictionary over time as you learn how they communicate through your searches. Some systems will allow you to encode those libraries into variant sets that you can use in all subsequent searches to ensure consistency and coverage. Translate the targeted concepts into their linguistic manifestations. For example, anti-competitive behavior. Whether a behavior is anti-competitive is a conclusion you make after looking at the behavior. People don't say anti-competitive. You need to look at what they did. In the past, we've seen discussions where anti-competitive practices were couched as a sports metaphor, such as, if we do X, it'll keep the plaintiff on first base. We've also deconstructed a concept like bribery by focusing on verbs of exchange as opposed to items of exchange. Next, you need to account for linguistic variability. Think about word choice, but go beyond synonymy to consider formal and lay uses. Targeting formal documents such as contracts versus colloquial documents such as emails. How does this affect your searches? Or consider scientific terminology and their lay counterparts, such as synthesize or make. And then consider the word form. For nouns, you need to consider both the singular and plural forms, and for verbs, consider the present, past, progressive, and perfect tenses. We often recommend using a wildcard operator to account for word variability. Try to model linguistic relationships as well. Combine your search elements strategically. At the broadest level, there is co-occurrence, which is usually modeled through an AND operator. And this is most of the searches that we see. But this doesn't model linguistic relationships. Instead, we look for a topicality or discursive relationship. If two concepts are closer to each other, they're more likely to have a relationship. We have rules of thumb for proximity operators. We use within 100 for words appearing within 2 to 3 paragraphs of another, within 50 for words appearing within 1 to 2 paragraphs of another, and then within 25 for words appearing within 1 to 2 sentences of another. If there's a grammatical relation, within 5 or within 10 of one another is used. And if there's a linear precedence, use a directional proximity operator. And then adjust your search strategy based on your results. If you need to narrow, you can decrease operator distance or add a search element, or broaden by increasing the operator distance or eliminating a search element. When you're narrowing or broadening, we suggest changing the distance by relationship, so moving from 25 to 50 as opposed to counting or guessing. This allows one to narrow or broaden the search scope in a methodical and purposeful manner. Once you have your search results, linear review is not the most effective use of your limited time because it treats all documents returned by the search as equally likely to be interesting. Be strategic about what you review, what you don't review, or decide to review later. Review the language that's been targeted by your search and only look at the remainder if it's relevant. Sort on different types of metadata to bubble things up. For example, if subject matter is in conversations, you can sort by emails with less than 5 participants and chronologically within that set. Abandon a search when the prioritized results are off-topic or uninteresting. Consider whether you need to narrow or broaden, and then determine if a different search strategy is necessary to find the material of interest. The first 3 steps of this approach, target definition, reduce the noise, and boost the signal, are generally done at the outset of the engagement and as new data or themes emerge. The last 3 steps of the approach, prioritize the data, search construction, and review prioritization, are typically search-specific. They're all part of an iterative search process to explore hypotheses about how key information might be communicated based on the factual background, prior and current experience, and search expertise. Technology should accelerate that process and minimize the risk of missing critical information. We'll discuss how this approach was leveraged as we worked with Covington on the matters we'll be walking through today. Steve?
Thanks, John. Thanks very much for those remarks. Now we'd like to turn to the case studies. And for each case study, Covington attorneys who were directly involved will describe the factual scenario and what needed to be achieved or resolved through interrogation of the data. Then John will describe specifically how Covington and H5 went about actually interrogating the data and try to relate some of that information back to aspects of the principal approach that he just described. And then finally, the Covington attorneys will describe the outcomes of the process, what they were able to achieve through this approach that they might otherwise not have been able to achieve or might have been cost or time prohibitive using traditional document review or less collaborative approaches. So with that, I'd like to turn it over to Josh Gonzalez, who will lead us through the beginning of the first case study. Josh?
Thanks, Steve. Hello, everyone. As Steve said, my name is Josh Gonzalez. I am an attorney at Covington and Burling. I am going to walk us through a little bit of the background for our first case study, describe to you some of the litigation goals we were seeking to achieve in this matter, and some of the document-related challenges we faced before kicking it back over to John to describe how we use technology to address some of those challenges. In terms of background, for case study number 1, we were hired to represent the former CEO of a large investment firm who was engaged in civil litigation with the SEC. The SEC complaint had alleged that our client, as well as other executives at the company, had made several material misrepresentations to investors in order to hide the deteriorating financial condition of the firm. The allegations in the complaint spanned several years, but our client was a relative newcomer to the firm and had only been present for about 1 year of the time period that was at issue. However, the SEC complaint drew little distinction between the time period that our client was there and the alleged misconduct. So one particular issue and goal that we wanted to drill into in discovery was exactly what our client knew about the financial condition of the firm and when he knew it. Something that made this difficult for us was the fact that the entity was in receivership and the receiver had waived privilege over a very large set of documents. So going in, we knew that the SEC had been producing to us millions of documents that we would have to review with a relatively small team to try to identify the knowledge that our client had and when. Unfortunately, our client was also not a very big email user, and so a lot of what we had to discover and drill into had to be inferred from the communications of other individuals at the company. Making all of this harder, and a very big point for us, was the fact that the matter was funded by insurance proceeds. The D&O insurance policy was paying the bills, and there was a limited cap that included coverage for both our client and the other defendants. The insurance proceeds in this case were a critical component of our settlement posture with the SEC. We wanted to bring our matter to a quick resolution, and as part of that, we were hoping to preserve as much of the insurance proceeds to offer in settlement negotiations. This meant that we had to interrogate a very large data set to look for key documents that we weren't sure what we were looking for in a quick amount of time and as cheaply as possible. And finally, within all of this, we also had to prepare for the possibility that settlement negotiations would fall apart. And so part of our work in interrogating the data was moving in parallel and not often congruous sort of tracks. We were trying to find key facts for settlement negotiations with the SEC and trying to find bad facts in preparation for the deposition of our client and the deposition of other defendants, which made for a lot of work, a lot of shifting priorities depending on the state of negotiations with the SEC and the state of the litigation. And so that sort of gives the background of what we were facing going into discovery. And with that, I will turn it over to John to describe the document review process and setup that we entered into.
Thanks, Josh. I think that the challenges here were large data volumes, incomplete knowledge, and some evolving themes, case themes. The SEC production was 2.2 million documents, and we used data reduction to prioritize 1.2 million documents for search. We did this through leveraging email threading, text deduplication, and non-reciprocal sender analysis to obtain a maximally unique data population for search. And then we also spent quite a bit of time on target definition. We developed a search specification with Covington that listed all the topics and subtopics of interest. And as an example, sort of generically, a broad example of a topic there was what processes are or were in place, who had approval, what other departments or personnel had oversight, or other key people involved. This is a topic that would require more extensive search to answer those questions. And then we also had narrow topics, for example, a change in disclosure language. Did our client approve this change? That's a narrow search where potentially one to a few documents were needed to answer that question. We also went through an iterative process of searching and delivering results, followed by Covington review of the results. We had a weekly feedback call where Covington could tell us what's interesting, what aspects of the themes they wanted to see more of, what they wanted to see less of. And at one point during the project, Covington deprioritized the reliance on process and procedures topic because they had found enough documents on that topic to flesh out what they needed to know. We also had flexibility to incorporate 3 new themes after a meeting with the SEC a month into the project. And this was really due to good knowledge transfer and scoping of those requests by Covington, followed by H5 leveraging our knowledge of the document population, the key people and subject matter, to efficiently deliver key documents on those themes. I think one of the interesting things that came up in this case was we found that one individual added a shrug emoji to questionable emails, and we were able to index that as a token class so that we could then search on those emojis. And that allowed us to search and find additional interesting emails. And a token class are effective at capturing dates, times, currencies, percentages, social security numbers, and credit cards. And so that was a unique aspect of this matter that helped bring additional key documents to light for the Covington team. Josh, do you want to speak about the results?
Sure. Thanks, John. I think just sort of stepping up to a high level here, the critical piece I think that we went into this project for, and the takeaway from this first case study for us, was that choosing the right technology to fit the project was very important. Our inclination sometimes is to march through every document and know everything that's in the document set. And in this case, that was not economical. It was not beneficial to our client, and we chose a technology of key document identification. We were not trying to do a massive document review. We were really trying to hone in on the most important documents for our client in this particular situation. And having search experts on the other side explain that to us, explain the technological process that they would be implementing, helped give us security in knowing that the process was sound, that it would achieve the goals we wanted to achieve. And importantly, this was important to the insurance company who was paying the bills, would be cheaper than what we might propose in a traditional document review situation. And so I think taking the time to work with your technology expert to discuss among the attorneys who are the legal experts what the goals of a particular project are, and then finding the right tool is critical to achieving the type of successful outcome that you want. And for us, that proved to be true. We felt very well armed for our settlement negotiations with the government. The insurer was very happy to sign off on the engagement of H5 as a technology vendor in this situation, and the end result was a far better outcome for our client than if we as attorneys had simply tried to engage in a traditional document review process. And with that, Steve, I will kick it back to you.
Thanks, Josh. Just a couple of quick remarks. I think John described that there's this feedback mechanism, right? So the way the process would work is the lawyers at Covington would give the team their search priorities, tell us what they needed us to find, and then we would make a delivery to them. And critically, the lawyers at Covington would, review and analyze the delivery, and then we would have a feedback call with them after that to see whether what we were finding was what they were looking for, or whether we needed to, change course somewhat. And that kind of collaboration is really sort of the whole point of this webinar. That, if you get search experts and lawyers to collaborate together, each doing the task that they're best suited to do, you're going to be a lot more efficient than if you don't. So this was a great example of that, and you can see from the slide, but H5 we turned up about 3,100 documents. That's how many documents we promoted to the Covington team to review out of 2.2 million. And as Josh described, the team was prepared for their settlement negotiations. They got what they needed among that 3,100 documents. You compare that with if you had, if you had utilized the sort of traditional approach to document review, where you'd have a team, coding those 2.2 million documents for, hot or issues or whatever, and they could code 10 to 20% of that set easily for an issue or hot. So then you've got, the Covington team essentially swimming around in, a couple 100,000 documents rather than 3,100 documents. And the last thing I'll say about it is that, sometimes when we describe these kinds of outcomes, lawyers and their clients have a concern. Well, how do you know you've found what you need? I mean, that number sort of scares people sometimes. They think, gosh, only 3,100 documents. What kind of confidence can I have that they found what I need? And the answer is really very simple. The Covington team tells us. I mean, if we haven't found what they're looking for, we keep looking. At some point, we may tell them, look, we've exhausted the search effort and it doesn't exist, or we've given you what we've been able to find. But more often than not, it's, we provide information that they need, and it doesn't really matter if there's more information about that topic. They have what they need, and then they, change our focus, tell us to move on to another issue. So, okay, let's turn to our second case study, and for that case study, Ben Haley and Randy Friedland are going to lead us through it. And so, Ben, I'll turn it over to you.
Thanks, Steve. This is Ben Haley. I'm a partner in our Johannesburg office, and I lead our compliance and investigations practice in Africa. The case study that I'll be discussing is and with Randy is an FCPA matter, and we're engaged by our client to conduct an investigation in a country in Asia on a highly compressed schedule. Most of our investigations are on compressed schedules, but this one was particularly time sensitive. And the project presented challenges in part because it could have been fairly characterized as a series of investigations within a larger investigation. We were asked to look at various whistleblower complaints involving conduct in different regions of the country. And the fact that the investigation focused on multiple time periods and geographical regions was challenging for a number of different reasons. First, as a process matter, it meant that we had to be collecting documents from separate regional teams led by different sets of employees in different business units. And as a result, we collected approximately 2 million documents from our clients' employees on a rolling basis over the course of several months. Second, once we received the documents, there were a number of analytical and fact development challenges. Our client operated in a highly regulated industry where it was subject to different regulatory regimes in each region relating to production, sales, marketing, and distribution of its products. Further, given the size and diversity of the market, employees in the company from different regions tend to use different market or industry jargon and different general vernaculars of everyday speech. So this posed challenges for our reviewers, and certainly would have posed challenges for our contract review team. And one of the values that we saw in working with H5 is that we could reduce the volume of documents to be reviewed by our core associate team, who really did understand the client's business quite well. In addition to the sprawling nature of the investigation, we also had to contend with the compressed timeline, as I mentioned. There were certain underlying dynamics, so there was pressure to come back with a quick conclusion on new whistleblower allegations so the company could make well-informed and timely decisions about reporting to regulatory authorities, third-party relationships, and personnel and other remedial actions. So we were engaged to conduct the investigation in the spring of this year, and we're on the ground in a matter of weeks to do scoping work and to coordinate collections. And in the 2 months following our engagement, we collected we collected about 2 million documents from a range of custodians. And as you might imagine, it took a substantial amount of time and resources to coordinate these efforts. And we were quickly under pressure to conduct interviews and move ahead. And having to cope with rolling productions was part of the challenge, because we were working to process as we were collecting and sort of constantly learning new facts. Using a traditional keyword search approach, we whittled that large collection down to about 212,000 documents. However, because of the need to work with a small core team of associates who really understood the business and the time pressure that we were under to prepare for rounds of document-based interviews on a compressed schedule, we just could not do a linear review on the time that we were given, nor would that have been a cost-effective option. So with the help of H5, we were able to progress our review to a place where we could conduct over a dozen comprehensive, document-intensive witness interviews on an expedited basis and bring the matter to close in a successful way. Let me turn it over to Randy, who can get a little more into the weeds on exactly how we achieved that with H5's help.
Thanks, Ben. My name is Randy Friedland. I'm an associate in the Washington, D.C. office. And as Ben previewed, we engaged and onboarded H5 after we had done a couple weeks worth of review in-house and about a month before our first round of interviews with some of the key witnesses who would help fill in the facts. We provided H5 with the 212,000 potentially relevant documents, as Ben noted, on a rolling basis. And they gave us several document deliveries totaling about 600 or so documents on a schedule that was convenient for us. And this flexibility was key for us to prepare for these interviews. The 609 documents was a good number for us, and as it was small enough that me and the other associate that was working on the matter could review the deliveries in full, and we could actually put eyes on all the documents that H5 sent us. A few observations on the process. First, the timing of when we brought H5 onto the project was ideal for us. By the time H5 began its work, we had conducted enough review to provide seed documents relating to each area of the investigation. H5 then used those documents in a number of ways. Substantively, the H5 team asked us for details on the nature of the allegations and what we had learned so that they could assess better understand the issues and assess where they might be able to find additional relevant documents. Given H5's technical capabilities, as were previewed before, they were in a position to operationalize on the information we provided them and conduct a much broader range of searches than we ever could do by ourselves. In our case, the seed set was also important to help H5 reviewers understand the specialized industry jargon and local usage that Ben was talking about. We thought the H5 team's willingness to familiarize themselves with these language cues helped them identify the best documents during their deliveries. Because we were committed to maintaining a lean team, it was really important to us that H5 provide us with document sets that were small enough that we could review and internalize it in time for our interviews. In our experience, there were two aspects to their expertise that made this possible. First, they were quickly able to identify the right documents. Their deliveries tended not to have many mishits, which made time spent reviewing their deliveries very useful for our team and very productive. Additionally, the H5 set the database up so our team could provide substantive comments on a rolling basis as the review progressed. The fact that we were able to provide this micro and macro level feedback based on actual documents was part of what enabled H5 to learn the issues so well. They really internalized our feedback and eventually were familiar enough to engage in substantive issue spotting themselves, which was really helpful to our team. Just as importantly, H5 was also a great partner to help us determine when it was appropriate to wind down our document review. Where we were finding documents to substantiate allegations, we need to know we had all of the relevant documents, which H5 helped us do. And where we were not finding such documents, we need to be sure we had been thorough in our review. We appreciated having a partner in H5 who could help make those decisions alongside us with access to good data. So overall, just to sum up, H5 really played a key role in our investigative process in this case and enabled us to stay agile in handling an investigation that was sprawling and ever-changing, all in a very compressed time frame. So that was our experience with that particular case study, and I will turn it back over to John.
All right, thanks, Randy. I think we've previewed quite well the challenges here around timeline, rolling data, and the community of practices or language use. Obviously, the timeline was quite compressed with having 4 weeks from start to finish from an H5 perspective. And then there was rolling data, both due to that timeline and due to geography constraints. So we conducted the work and the data that was available to support those witness interviews. And so we took 3 weeks for the first 2 themes that we had and provided 4 deliveries of about 500 documents total. And then as new data was provided, we searched that over the last week and delivered about another 100 documents to make sure the Covington team had the information they needed to prepare for those interviews and to close out the work. The communities of practice. So again, there was varying geographical regions. There was dense accounting material that had to be accounted for and sales and marketing material. And then it was also compounded by the unique jargon or ways in which phrases of speech were used that were hard to decipher. And I think, as Randy said, having those key documents that the team had found at the outset was helpful, but then allowed us to model those documents as well. And I'd say that the target definition here was particularly good. Covington provided an extensive background in the case, a chronology. They provided those key documents that they had found through their review to date, and then they really did understand or make sure that we understood the narrative that they were investigating and the documents that would be of interest for that. And as Randy said, that investment in target definition up front allowed us to start finding, spotting potentially suspicious behavior that we could point out to the team, even though they had not specifically asked for that type of search or that type of behavior to be targeted. And so we're able to, add value there. We also focused on boosting the signal here. So we use communication analysis to target direct communications with key actors and target verbs of exchange, along with other relevant concepts to get at the alleged bribery behaviors of interest very quickly. And then from a data prioritization perspective, when new data was available, we were able to incorporate that and determine very quickly, based on our flagging and email threading, whether there were any new unique branches of communications that had been previously delivered as interesting. I think just in terms of knowing when you're done and when to wind down, as Randy mentioned, oftentimes we'll characterize our results and characterize everything that's been done to search for a particular theme of interest. so that the Covington team had insight into that. And then if requested, we can also provide broader search results to show what's still out there that's at least somewhat relevant to the themes of interest, so that the team can get that experience as well. Ben?
I don't really have anything more to add beyond what John said, except to just pick up on a point that you made, Steve, is, I think anybody who's worked with our firm knows that we have a very collaborative model, including, in-house and between our lawyers, but also with our clients and with our consultants and service providers. And I think that we sort of benefited from that here, and H5 was a terrific partner in sort of onboarding all the information that we had, and really putting that to use to bring this together, and we were able to quickly achieve all the objectives for our client on this on an extremely tight timeline. So this was certainly a one where I think we all worked together well for a good result for our client.
Great, thanks Ben, thanks John, Randy. One quick point that I would make, Randy and Ben stressed how small the team was at Covington that needed to consume the search results, and that's a great example of if you communicate with your search expert and help them understand what is the size of the team that's going to consume this information, then the search expert can sort of modulate their work to make certain that they are being as broad or as narrow as is necessary to work with that size team. We see that a lot. Not every case we work on is at that small of a team. Sometimes it's a much larger team. So anyway, thank you all for that. Let's turn to our last case study, and to lead us through that is Aaron Lewis. Aaron?
Thanks, Steve. My name is Aaron Lewis. I'm a partner in Covington's White Collar Defense and Investigations Group based in Los Angeles. This case study focuses on a DOJ-led False Claims Act investigation, which began with the receipt of a subpoena from the Defense Department's Office of Inspector General, served on an aerospace and defense manufacturer based here in Southern California. The subpoena called for information related quite broadly to a number of quality issues allegedly affecting several of the company's product lines that encompassed dozens of the company's products. The subpoena called for information related to the company's quality policies, its testing procedures, its supply chain, its sales, and ultimately encompassed a broad range of documents, internal communications, marketing materials, technical documents, formula, foreign language documents from manufacturing facilities located abroad, and technical drawings related to some of the company's products. We immediately began the process of identifying potentially relevant custodians and locking down documents. This step would have been normal in any internal investigation, but it was particularly essential in this one because the Justice Department had heard from a tipster inside of the company, which was in the process of relocating a manufacturing facility from one site to another, that the company had issued essentially a document destruction notice. This wasn't an accurate characterization of the document. It was basically an admonition to get rid of anything that wasn't needed in the new facility. But the government was immediately skeptical, understandably, and incredibly aggressive, and made a number of assertions about our client's intent to obstruct their investigation that put us in a tremendously fraught posture kind of out of the gate. So it was essential that we kind of learn the facts related to the underlying allegations and the facts related to our client's efforts to comply with the government's subpoena. The entire posture was made more complicated because the company was skeptical that it had done anything wrong. And the investigation immediately drew the attention of the firm's CEO and its board of directors. So kind of out of the gate, we collected a huge volume of data, approximately 1.25 million documents that we had to review in order to win the race for the facts and really understand what was going on. At the time, I had returned to the firm recently from government, where I was in AUSA, and so I was not familiar with the principled approach that H5 has described on this call. I was familiar with the old methodology, and I expected that we would have to linearly review this kind of sea of data in order to understand fully what was going on. But that was not, in fact, what we ended up doing. We assembled a team of case experts, search experts, and technology experts, and used this methodology to achieve what I really consider to be a remarkable result. Within the first month, really the first 2 weeks of our review, we had identified a set of key documents that allowed us to understand the core facts related to the government's allegations and allowed us entirely to dispel any suggestion that our client had acted to obstruct the government's investigation. As a result, I was able to spend less time thinking about how to find documents and more time understanding what the key documents had to teach us about our client's conduct and organizing those documents to frame my client's defense. Based on the understanding that we developed by the review of these documents, we were able to make representations both to our client's board of directors and its CEO, but also importantly to the government about what happened and what importantly did not happen. And those representations have been tested by 2 government investigations over the course of several years, and they're still accurate today. The government has found no significant fact that we were not able to identify in the first month using this methodology. As a result, we've built an incredible credibility with the trial attorneys at DOJ who are handling this investigation. And that credibility is the basis of our effective advocacy on behalf of our client. And I do not think that we would have been able to achieve it using a different search and review methodology. So I'll turn it over to John to talk about the nuts and bolts.
Thanks, Aaron. I think the challenges here were around incomplete knowledge, the communities of practice speaking about a highly technical subject matter, and rolling data. As Aaron described, the government had either a potentially harmful document and/or understanding of practices going on within the company, and we really used a combination of search construction techniques to effectively target the subject matter of interest, and then leveraged review prioritization to really just look at the search hits that enabled us to quickly find documents that would provide additional context around the company complying with the subpoena and/or obstructing the investigation. We used search construction as well, and our tool has flexible search syntax that allowed us to search for discrete product and part numbers that might be very challenging to target accurately in lesser tools. I think the other piece that played out here is that one of the things that we do is track all the searches that have been performed for a particular request or for a particular topic, and the collections in which those searches were executed. And the search experts provide notes on the efficacy of those searches so that we know whether or not that is something that we want to leverage in the future. And so, when the criminal investigation started after a period of inactivity from a discovery perspective, we had to start back up and search in new data, and those being able to leverage those searches and know which searches were effective at finding key documents was something that was really helpful as we moved into that phase of the project.
I guess I'll offer just a cap that may take us back to the operative metaphor, winning the race for the facts. So when I talk to clients, I often use the metaphor or use Usain Bolt, the sprinter, as a metaphor. So the New York Times ran a story following the last Olympics that kind of timed him coming out of the blocks. And as it turns out, he's really slow. He's like one of the slowest people to get started. But once he reaches top speed, obviously he blows everyone away. And in my practice, which is often reactive to government investigations, that's how I think of it, right? We are almost always the last to know about the allegations. They come at us via subpoena, some other notice of government enforcement risk. And it's our job to work with our clients and experts like H5 to win the race for the facts. And compared to the way that we used to do things, the way that I did things in government, this methodology, in my view anyway, is hands down better. And I can't imagine kind of engaging in my practice without these tools going forward.
Thank you, Aaron. Thank you, John. A couple of observations about this case study as well. Aaron, one of the things that you said was that, the process allowed you to spend less time looking for documents and more time learning from the documents. And I think that's a really critical concept when thinking about, how to work with and utilize search experts in this kind of endeavor. Search experts are experts at finding documents. Lawyers are experts at interpreting the factual information that exists in those documents to decide whether or not they matter to their case. And I think a lot of times those two things get mixed up, and people think, well, okay, a lawyer has to look for the documents because the lawyer is the one who has to decide whether the document matters or not. And that's not exactly true. I mean, I think what this collaboration shows is that if the lawyers can effectively describe target to search experts, then search experts who are trained to look for stuff are going to be much more efficient actually finding documents that have those facts in them. And then, of course, it's up to the lawyers to review those documents and decide whether or not the information that's there is helpful or not. So that's really the crux of the whole thing, is how do you divide up the division of labor and get to the facts as quickly as possible, utilizing the right kinds of competencies at the right time. So that's about it. I think we're about a minute and a half away from being finished. Anybody on the panel have any last remarks you want to throw in? Okay. Then what I would say is thank you to all of you for attending. If you are interested in more information about anything that we covered today, you can please feel free to contact any of us on the panel at H5 or at Covington. There is information that will be available for you to download afterwards, the deck, as well as some information that hopefully can help you understand exactly the issues we covered. And there's our contact information for anyone who'd like to contact us. And again, any questions that come to mind afterwards, please just send us an email and we'd be happy to respond. And with that, thanks to our panel, and thanks to all of you for attending.